Welcome back to our mini-series exploring how states respond to civilian harm from their own military operations. I'm your host, Mae Thompson from Ceasefire, the Centre for Civilian Rights, and in each episode we'll be joined by leading lawyers, experts, practitioners and military personnel to discuss the evolving landscape of military accountability, the gaps in existing redress mechanisms and the potential for a UK civilian harm redress scheme. This mini-series is part of a joint project by Queen's University Belfast, University College London and Ceasefire, aimed at advancing legislative amendments that will provide reparations for civilians harmed by the UK's involvement in warfare. The project is funded by the UK Research and Innovation Arts and Humanities Research Council. We have some brilliant guests joining us today, so let's dive right in. It's my pleasure to welcome Dr Elizabeth Stubbins Bates, who has taught at LSE, SOAS and the University of Oxford. Her doctoral and postdoctoral work has been published by the International and Comparative Law Quarterly, the European Journal of International Law, the International Review of the Red Cross, and the Journal of Conflict and Security Law, among others. Elizabeth is currently working on her monograph, A Framework for Compliance in International Humanitarian Law, which is under contract from HART. And she is the author of Ceasefire's November 2024 report, Strengthening UK Military Investigations into Civilian Harm Towards Compliance, Mitigation and Accountability. Mark Lattimer, Executive Director of Ceasefire. Mark has regularly served as an expert for UN agencies, the Council of Europe and the Organisation for Security and Cooperation in Europe. And he has written extensively on the duty to investigate civilian deaths in armed conflict, including in his book, The Grey Zone, Civilian Protection Between Human Rights and the Laws of War. And Conall Mallory, a senior lecturer in law at Queen's University Belfast, and a fellow of the Senator George J. Mitchell Institute for Global Peace, Security and Justice. Thank you to all of you for joining. I'm really excited for this conversation on investigations and redress for civilian harm during military operations. And in this mini-series, we're exploring the potential for a standing mechanism for civilian harm redress. But of course, before civilian harm can be addressed, it first needs to be acknowledged, tracked and investigated. So when we're thinking about what such a mechanism could look like, it's important to consider the UK's current approach to all of these things. Mark, I'd love to come to you first, just to give us an idea of what it means to track civilian harm and what we know about how the UK does this.
Thanks, Mae. Yes, well, I think the first thing to do is to draw a distinction between civilian harm that's caused in the home environment and civilian harm abroad or overseas. If we look at the armed conflict in Northern Ireland, the so-called Troubles, we know that 3,600 people were killed. There is a dispute or a debate that still exists as to how, in some of those cases, how people met their deaths. But we know that they were killed. We know the names of the people who were killed. We know who they were. They're real human beings to us. And that there's a big distinction between that and the more recent wars that the UK has fought in Iraq, Afghanistan, Libya, more recently in Syria, where there hasn't been any significant or systematic mechanism to track or record civilian harm. So we do know casualties among service personnel, but we don't amongst the civilians. And there remains a huge dispute, not just about the numbers killed in those conflicts overall, but also about those who were killed or harmed as a direct result of UK military action.
And from an outsider's perspective, it sounds quite shocking to hear that the UK, isn't tracking harm as a result of its operations and that difference that you mentioned between how we've done that in Northern Ireland versus sort of operations during conflict in the Middle East. Clearly it is no simple task, but maybe you can just share what some of the challenges have been or why the UK hasn't been doing this elsewhere.
Well, I think once again, to draw a parallel or to draw a comparison between the Troubles, what you had was civil society groups, academics actively working on collating figures, relating them to the conflict. And eventually the UK government essentially accepted those figures. So you had this sort of this collaboration, which was really important. And I think in expeditionary warfare or operations overseas, as the UK generally refers to them, you don't have that. You have a failure really to engage with civil society. So most of the figures we have from the Iraq conflict, for example, were collated by civil society groups, eventually partly by the UN, but also by civil society groups, such as the UK-based Iraq Body Count. But then there is no engagement from the Ministry of Defence or from the UK government on that information. And I think that's a major challenge. You also have this general reluctance to address the wider harm caused as a result of military operations. I mean, famously, the American general Tommy Frank said, "We don't do body counts." And I think that sort of culture or that attitude has remained. And it was remarked on by the Iraq inquiry, by the Chilcot report, who said, unless you can have some idea, some accurate idea of the civilian harm caused, you won't actually end up with a full picture of the effect of a military operation. And understanding civilian harm is essential for accountability, for military accountability and for political accountability. And where there have been inquiries or investigations, proper investigations in things that have gone wrong or civilians that have been harmed as a result of military operations, this is often been the result of extensive public pressure and in particular legal action. So we see at the moment there is now an ongoing public inquiry, the Afghanistan inquiry, on alleged killings by UK special forces in Afghanistan. But that really was prompted by a series of cases before the High Court, judicial review cases.
Yeah, and you mentioned some of them there, but on investigation, Elizabeth, I've got your brilliant report here next to me that you wrote for us, and in it you really thoroughly evaluate the UK's investigatory practice, and where Mark was previously talking about tracking civilian harm, which is accounting for all the types of harm. It's, investigations only take place where there are concerns or allegations that a crime or a criminal law violation has taken place. Is that right? And how would you describe how the UK military investigations since the turn of the century, particularly in Iraq and Afghanistan, and are there any particularly illustrative examples?
I'd say you're almost right. So civilian casualty tracking is about creating a comprehensive data set of all types of civilian harms. So civilian losses, deaths, injuries, but also wider cumulative and reverberating harms from kinetic attacks in armed conflict. Civilian casualty recording is one subset of that, perhaps, where you're tracking those who've been lost and you're identifying them, which is also one means of fulfilling IHL's obligations in relation to the missing and to the dead. But in the case of this century's Ministry of Defence investigatory practice, it's certainly true that investigations have only taken place, as Mark said, after significant legal action or significant journalistic investigation. And they've only taken place reactively in this very narrow criminal focus for investigations. So only when there are concerns or allegations that a crime or a violation of international law, particularly a war crime, has taken place. Now, Ceasefire's report from November 2024 argues for a different approach. It argues that investigations in a broader sense, operational investigations to ascertain the facts and their causes, are an important tool in civilian protection. So they can be specifically a means to respect the Geneva Conventions and their additional protocols in all circumstances, a means to suppress all violations of IHL, not merely to repress grave breaches. And it can also, these operational investigations can be part of the evidence needed to exercise constant care to avoid and in any event to minimise incidental civilian casualties under the principle of precautions. It's important to recognise that IHL is a creature of state responsibility. So it's primarily the state that is responsible for breaches of IHL. it's not only an individual defendant. So having this narrow criminal focus where you're looking for evidential thresholds that might enable a prosecution against an individual defendant is too narrow an approach, too reactive an approach, and it misses out the preventive potential of operational investigations as a means of civilian protection. I could also add that, in fact, the political declaration on explosive weapons in populated areas recommends that civilian casualties be recorded and tracked, with data disaggregated by sex and age, shared and made publicly available where possible, as a means of preventing civilian harm. So it's not merely in NGO and academic circles that we're talking about operational investigations as being a tool for civilian protection. It's also in recent and important IHL soft law.
You argue that the UK is currently doing this very badly, and it has resisted as well, despite significant civil society pressure really reflecting on its current practice. Why do you think maybe that is? Why do you think there is resistance to having a stronger framework? Or why have they taken this very narrow interpretation in the first place?
So I can think of three reasons, and two of them are most definitely not an excuse. So one of them would be a historical practice, which is not consistent with transparency. And that historical practice continues again and again in institutional memory. So we can think back to the British withdrawal from Kenya when colonial records relating to the Mau Mau rebellion and the ill treatment of detainees were burnt. We can think about practice relating to the Official Secrets Act, where there's a tendency only to discuss past deployments and violations of international law which are alleged to have occurred in those past deployments once the time period of the Official Secrets Act has expired, or until historians and the relatives of victims are unable to advocate for redress. There are also political disincentives. So one of the findings in the report was that redress is conceptualized as a creature of human rights only, without considering the importance of international humanitarian law. There's this strong lobbying that individual service personnel should not be held accountable for breaches of international law in operations. And something that strengthened those political messages is the passing of the Overseas Operations Service Personnel and Veterans Act 2021. And the civil litigation long stop in that legislation might allow previously closed investigations that were closed for flawed reasons to remain unchallenged. The third is perhaps a little bit more understandable: the international law and state practice dimension. So in the 1990s and the early 2000s, the emphasis in accountability discourse was on the ad hoc and then the general establishment of international criminal tribunals, sometimes combined with truth and reconciliation initiatives, in states where war crimes, crimes against humanity or genocide had occurred. And then there was very fact-specific human rights litigation, where the co-applicability of human rights law and international humanitarian law was often hotly contested. In conflicts since then, human rights litigation in relation to armed conflict and military deployments has very much expanded. I've had the range of fact-finding missions established by the UN human rights system, and the breadth of situations considered by the International Criminal Court. So in that time, there's been an emphasis on reactive fact-specific investigations throughout the international community, where alleged violations of international law arise. It's much more recently that scholars and practitioners have emphasized the indirect and reverberating effects of kinetic attacks and the importance of civilian casualty tracking, which is broader than civilian casualty recording. It's up to scholars and civil society to keep reiterating this new best practice, that investigation does not only mean gathering evidence where a war crime is suspected to have been committed, and that comprehensive operational investigations can improve compliance with IHL and the full protection of civilians.
And when we're talking about reverberating or indirect, also compounding effects of conflict, because I think this is a really important point when we're looking at sort of contemporary conflicts, such as, that are currently ongoing in Sudan, Gaza, Ukraine. Could you just give a few examples of what those actually are?
Yes, certainly. So the spread of disease from targeted health and sanitation facilities, for example, starvation from blocking humanitarian aid, attacks on civilian infrastructure, on a safe water supply, for example. These are all reverberating harms that do constitute harms to civilians that can be cumulative over the course of the conflict and are not only limited to deaths and injuries from kinetic attacks.
And of course, these also constitute, grave human rights violations. So, Conall, perhaps I can bring you in here just to help us look at this more through a human rights lens. And as rights holders, why is it so important that civilians have access to prompt and comprehensive investigations?
A lot of this will build really off what Elizabeth has just been talking about. But what I'll start with, I think, is the recognition that we have to identify that an investigation acts as a gatekeeper to other pathways. Okay, so an investigation might be the pathway towards legal liability and whether there's been a violation under IHL. So a pathway towards some type of justice framework. But the investigation may also be the pathway towards some type of reparation as well. Maybe that's merely an apology, an acknowledgement, an acceptance of the harm, or maybe it's some form of compensation. Without the investigation, you're not respecting the dignity of the human being who has been killed. And with dignity being an underlying principle which underlines human rights alongside universality, it's somewhat displacing the rights of the individual to not have any investigation whatsoever. To recognise that. And I'll give two other reasons related to rights protection, which I think are salient here. One, just drawing on Elizabeth's point, is there are really core operational reasons to conduct the investigation, to correct mistakes, to correct areas of malpractice, to identify areas of good practice and bad practice, to learn lessons. All of this is important, not merely for the in-theatre conflict or for the remote conflict which is taking place where the civilian harm occurs, but for future conflicts as well. If you recognize the dignity of the individual and of the human being, and then you recognize that if you're making mistakes in one conflict, you can make mistakes in future conflicts as well. And so it merits investigations to make sure that your practices are correct. The third point, which I'll talk about, is really reflecting on the nature of the operation as a whole, and where the state goes after the operation. For an operation to respect the rights of individuals, or at least to recognize their rights, we have to recognize that there is almost an optics element where by the way in which the dead are treated, or those who are harmed, whether it's their property or whether it's the person, are treated, it reflects the way in which the operation has been undertaken and how it's going to be viewed, both by those who have suffered and by the domestic British public who have an interest in it as well. Now, if you don't investigate actions of civilian harm, if you don't investigate swiftly, what the conflict in Northern Ireland demonstrated is that you lose trust amongst the domestic population very quickly. Accusations of collusion and accusations of deliberately ineffective investigations become rife. The armed forces then lose legitimacy within the populations. And we know that the passage of time makes it far more difficult to bring any prosecutions whatsoever. The passage of time, particularly in respect of investigations, means that evidence is gone or evidence is not accurately recorded. And the final point on this, we often hear that and we heard it this week at the Conservative Party conference, that the expansion of human rights into military affairs of this nature set unrealistic expectations upon the armed forces. Well, one way to counter this is that if you investigate as thoroughly as you can, as quickly as you can, and the Henrik's report even noted, if you document the difficulties with the investigations as swiftly as you can, then the state can demonstrate that it is taking every effort in order to uphold the rights. And if there are practical and operational difficulties in conducting those investigations, then they can be documented to mitigate any accusations of failure later on down the line.
Yeah, absolutely. And, in counter-insurgency operations in Iraq and Afghanistan, exactly the same as you've just mentioned in the Troubles did actually play out in terms of losing the trust of local partners and, the legitimacy of operations on the ground, but also from the British public as well, when we're seeing the, high reporting from, the media and civil society of alleged harm that the UK says, well, we know nothing about it, or is unwilling to take any sort of responsibility for. And on a human level, rather than a legal level, why are investigations important for those that have suffered harm?
I mean, this is perhaps should be the forefront of the consciousness in it. The reasons why they're important are deeply personal. They're personal to the individual, and they're personal to the community and to the society within which the civilian harm, whether it's property or whether it's to human life or to physical injury, where that's taken place, they will be deeply personal, because all humans have their own individual consciousness, and they've lived a particular journey, which is to define what will be important to them. But what we share is that, by and large, whenever a civilian harm takes place, people want to know what has happened. They want to know why it's happened. They want to know how it's happened and when. Now, that might not bring closure. It might not bring a sense of justice. But what it at least does is that it brings recognition to the families of those who have been killed, or to those who have been injured, or to those who have lost property. Recognition that the harm was real, that the harm was suffered, that they're not being ignored, that they are an individual with dignity themselves. Whenever we draw on the conflict in Northern Ireland, we often hear of information coming to light decades later, and sometimes the families will say, we don't need to know anything more than this specific piece of information. We want to know where our family member was whenever they were killed. Sometimes they want to know who they were with. They want to know the level of suffering. There are instances examples that are given of wanting to know whether or not a family member was wearing a particular piece of jewelry, a watch, at the time of the death, because it was an individual human being who died. It was a personality. It was somebody with personal characteristics that was lost. And so it is a reminder that behind all of the numbers, behind the terms of collateral damage and whatnot, that there was an individual and a human there.
Yeah, absolutely. And throughout this project that we've been working on together, we've mostly focused on a system for delivering compensation for civilians that have suffered harm as one way to respond to the suffering that they've endured. But I think a comprehensive redress scheme could also introduce statutory requirements for tracking and investigating harm. And where previous redress initiatives have largely resulted from civilians themselves bringing claims or allegations, a better process might be to take a more proactive approach. So, as Elizabeth and all of you have sort of outlined in some of the recommendations that you've sort of given already. I'd love to hear your thoughts on whether you think that's a good option, or potential other policy options that you see that could improve the UK's approach to tracking and investigating civilian harm.
So I see the promise in that. A comprehensive redress scheme, especially with statutory underpinnings, could serve as a guarantee of non-repetition if it really mainstreams that civilian casualty tracking as a strategy for civilian protection. It could be an important step forward, but I'm sceptical. I'm firstly sceptical that a statutory scheme would last, given the current assertions that there are two political parties that might seek to withdraw from the European Convention on Human Rights subsequently, with all the implications that that would have for the Human Rights Act and for statutory interpretation in this jurisdiction. And I'm also sceptical that any such statutory scheme would be comprehensively implemented while it's in force, given historical tendencies towards a lack of transparency and narrow criminal-focused investigations by the Ministry of Defence. So I would suggest instead that the UK might implement the now closed US Department of Defence's Civilian Harm Mitigation and Response Action Plan, which was created by the Biden administration in 2022 and then closed by the Trump administration earlier this year. That initiative is not limited to investigations, but it's a general integration of civilian protection in doctrine, in training, in data management, and it's a means to to address target misidentification and cognitive bias in targeting. Alternatively to that, or perhaps in addition, would be to adopt aspects of best practice from the 2024 Dutch roadmap on civilian protection, which is similarly strong and has benefited from civil society and academic input. And that recognises the breadth of cumulative and reverberating civilian harm. So it includes reverberating effects on livelihoods, on education, on healthcare, and on water treatment facilities, for example. So there's international best practice, even though the US is not currently using that best practice, having disestablished a relevant civilian protection unit within the DoD. And the UK could learn from, and indeed could show leadership in civilian protection by adopting some of those best practices in investigation.
I think that's really interesting. I'll just go back to something that Elizabeth was talking about earlier, which was about the way in which the UK tends to have an approach that prioritises or immediately focuses on criminal investigations. And I think this is really interesting if you put it beside what you were just talking about, Mae, and the possibilities of a wider, more comprehensive approach to both tracking and redressing civilian harm. Let's just sort of take one case, probably the most well-known case of civilian harm from the last 20 years is the Baha Mousa case. So Baha Mousa, to remind people, was a hotel receptionist in Basra in southern Iraq, and he was arrested by the British Army. He was detained, and over the course of approximately 24 hours, he was beaten to death. Now, what then happened is really interesting, because it required literally years of litigation, including finally before the European Court of Human Rights, to push for an adequate response to the situation of Baha Mousa's surviving family and their search for justice. On the way, there was, once again, because of litigation, forced a UK public inquiry, the Baha Mousa inquiry, which found that many of the practices that had been inflicted on Baha Mousa and indeed on other detainees were ones that had occurred earlier in the Troubles in Northern Ireland and were clearly illegal. So why didn't this stuff come out earlier? Why wasn't there an adequate response? Well, one of the things that was very apparent and was referred to by a criminal court judge was the closing of ranks. So something goes wrong, something very serious goes wrong. The British system immediately switches to a criminal investigation. There is a closing of ranks. And this we've seen time and time again, that it's usually very junior service personnel who are in the frame. Everything switches to the criminal track. The corporate response is precisely the opposite of what Conall was talking about. Instead of thinking about something's gone wrong, let's find out what went wrong so it doesn't happen again, is completely put to one side, while criminal investigation processes, often taking years, take place, focus just on the junior service personnel who are directly implicated. So you see this pattern of things which really is almost designed to prevent lessons being learned and justice being served to those who were affected. Whereas if we could somehow encourage a process which was much more open, which as Elizabeth pointed out, has fact-finding, a more open fact-finding process much earlier on in the train of events, then sure, if there was an alleged war crime, sure, there needs to be accountability for that. But to have a process which allows the service involved and of course the Ministry of Defence to start learning lessons, and to ensure that there is a process whereby the civilians involved can get justice. And people often talk about the cost, but the amount that is paid in compensation is is a very small proportion to the amount that is spent by the Ministry of Defence on defending actions, on it's essentially on preventing information from coming out, and then finally, when they are forced to, launching very expensive public inquiries.
I would add to Mark's vital points there. If we move towards a better system of tracking and investigating harm, then we're going to do a better job of looking backwards and understanding what has happened. And I mean that in the macro sense. There is still an ongoing debate in the United Kingdom as to the extent to which the United Kingdom's armed forces committed violations of international human rights law and international humanitarian law throughout the conflicts in Iraq and Afghanistan. We're approaching 2 decades on from many of these events that we're talking about. And there is a battle over the narrative of what happened there. Elizabeth had mentioned the Overseas Operations Act, an act which was brought in entirely on the premise that the British soldiers had by and large been absolutely perfect in theatre, and that a few rotten apples had rightly been criminally prosecuted. But on the whole, there was the real problem was the pervasive litigation being brought by activist left-wing lawyers. And this notion of vexatious litigation, it was mentioned again this weekend in terms of Conservative proposals now to withdraw the United Kingdom from the European Court of Human Rights. What we've done is that we've slipped into a narrative which contests whether or not there was actually violations of international humanitarian law in particular in these conflicts, which is such an important but narrow focus if we take a couple of steps backwards. Beyond those who were like Baha Musa, who were tortured and killed, there are scores, there are hundreds of people who were killed in what we would define more broadly as civilian harm, which might have incurred legal liability, which might not have incurred legal liability. And there were those who were killed by British Army convoys that were racing through the desert and they were knocked down. And that death of that human being's life was just as worthy as any other life was taken during the Iraq conflict. If we move towards a better idea of tracking and investigating harm, then we'll be recognizing across the broad brush what the actual picture is, so that whenever we look back on these conflicts in the future, we can have a more authentic account of what took place in them in order to go forward. But as we've discussed, there is something of a cultural predisposition towards not doing this.
I think also having these broad civilian casualty tracking operational investigations into civilian harm and focusing on maximising compliance with international humanitarian law and maximising civilian protection will to some extent draw the sting from the political messaging that all accountability processes, including criminal trials, are a creature of human rights law and not international humanitarian law. The flaws in those Ministry of Defence investigations include, as Mark said, this closing of ranks and a defensiveness whenever a criminal investigation took place. But there are also weaknesses in initial forensic investigations and in record keeping that then helped cause recurrent investigations when it was plain that something needed to be investigated and then reinvestigated. So having systems in place for comprehensive civilian casualty tracking is one means of already collecting the data as a routine way of implementing international humanitarian law and not thinking reactively and defensively with a criminal lens alone. So that could actually be more constructive, and it could actually save funds that would otherwise be diverted to expensive public inquiries, as Mark was saying, and to reinvestigation and in the criminal sphere.
Yes, and I don't know whether it's worth getting into all these arguments, the political arguments that there are at the moment, but obviously there is this push, there has been for some years, for the UK to withdraw from the European Convention on Human Rights, and much of the analysis on which that is based is criticised by human rights lawyers, fairly obviously, for being sort of plain misunderstandings of what the situation is under the Human Rights Act. But from my point of view, I think that the people who are putting forward this idea that the UK should withdraw from the UK Human Rights Act, when it comes to extraterritorial operations, when it comes to military operations, their argument is to say, it should be the law of armed conflict, i.e. international humanitarian law, which takes precedence, which covers those, and not human rights law. Now, I understand that argument, but it seems to me that those people, they never read the Geneva Conventions. They don't understand IHL, because the duty to investigate is there as well. If you look at the Bahamous case, it's very obvious. It's in the Fourth Geneva Convention. There is a duty to conduct an official inquiry. Those are the words, Article 131. Those are the words in the Geneva Conventions. Conduct an official inquiry where there is a case of a civilian detainee who has died. And you have to ask yourself, well, what did the UK do to fulfill that obligation of the Geneva Conventions before you even go as far as to say, and what about the human rights obligations? So pulling out of the UK Human Rights Act is not going to remove the obligation on the United Kingdom to conduct investigations, both in cases of civilian detainee deaths, but also, I would argue, in other cases where you have the dead or the missing from armed conflict.
I think this speaks to as well the fact that no matter how strong your policy framework is, that actually what else is required is a shift in military mindset. And I think we've seen that not only from researchers in the UK, but also in the Netherlands and the US, where researchers have found that this imbalance between how military actors perceive the relationship between military effectiveness and then civilian protection and compliance with IHL needs to shift. I don't know how we achieve that. I think it will require the ongoing work of civil society and academics and researchers. And that also makes me think of when we're thinking about a policy framework, how important is it that there are maybe baked in channels for that important exchange between civil society and the MOD, not just sort of international organizations, but also for civilians themselves that have been affected.
With a question like that, there's a stunned silence. we don't quite know how to. But to me, it is, well, yes, it is partly a military culture issue. I would slightly nuance that, though, to say that I think often from, most people who come from a military background, including in particular from the legal services of the three services, so say from Army lawyers or Air Force lawyers, Navy lawyers, they completely get it, because the question of adherence to the Geneva Conventions is only a sort of bedrock for general adherence to military law, to the whole discipline in the armed forces that you need in order to have an effective fighting force. And therefore, I think they completely get it. I think there's a particular issue sometimes with the Ministry of Defence, who, have this hear no evil, see no evil attitude, and that has been encouraged by certain sectors of the popular press. So you do get this kind of disjunct between actually the experience of military personnel on the ground who understand the need for discipline, who don't want to see civilians hurt, and the press office at the MOD who continue this sometimes sort of farcical picture, painting this picture that there is only perfection, that no one's been killed, nothing's happened, it's all perfect. And I think there is often, there is really the root of the problem. Where I think there is a real culture problem is the attitude that the UK has towards special forces, which is unique in the world, which is unique amongst its allies. This idea that everything that special forces do is completely secret and that you must never talk about it, and it must never be talked about in Parliament. And all the major political parties buy into this idea, but it's not shared by the US. In the US, you can debate special forces activity and accountability in Congress. It's not shared by all the other NATO partners. it was actually a creation of the 1980s, and it has been really damaging to accountability. There is now this attitude that somehow special forces are not covered by the law, and of course they are. They are obliged to comply with the Geneva Conventions, just like every other branch of the armed forces. But this thing has developed in the UK that somehow they are different, and somehow you can't talk about what they do, and they are at one remove. And I think this has been genuinely damaging and created a culture of impunity within the special forces that really we need to look at.
And of course, we do have the ongoing Afghanistan inquiry,
Absolutely.
which is looking at allegations of special forces, and we'll be closely following and awaiting the findings of that. Well, thank you so much. I want to come to you, Elizabeth and Conall, just in case you have any sort of final closing reflections.
I'll just make one very, very quick one. Just on if we just go back very quickly to military investigations, to prompt and effective investigations, I've laboured the point of how important that is to the individuals who are suffered, to their communities, to the individual rights holders. It is critically important to soldiers as well. It's critically important to young men who are sent overseas into very, very difficult situations, who find themselves following orders and as Mark said, exercising discipline in many circumstances, and in many circumstances after they've had an engagement or after something has happened, they need to be properly debriefed. They need to have proper interviews, proper discussions, because the time spent doing that in the immediate aftermath will save them years later from going through extensive litigation and extensive rehearings and trying to remember things. It's too big an example to be a good example, but you will see in Belfast courts this week, they have Soldier F from Bloody Sunday, who over 50 years after the Bloody Sunday atrocity is facing criminal prosecution. These are difficult things to try so far after the date. And soldiers themselves, certainly those who served in Iraq, have accounted that they, to an extent, I think that they wish that they had swifter and better military investigations at the time.
Absolutely, that's such an important point. Thank you so much for raising that. Thank you again to all of you, Dr Elizabeth Stubbins Bates, Lattimer, and Conall Mallory. Thank you for listening, and we'll see you next time.